ladies, gentlemen, good afternoon. Welcome back, and we would like to invite everyone, please make your way back to your seats as soon as possible, as we would like to resume our afternoon section now. Thank you. 咁多位來賓喺呢個時候咧，想邀請大家咧盡快咧返回你哋嘅座位，同時提一提大家咧，記住將你哋嘅手提電話調校至靜音模式。我哋下午嘅環節咧將會立即開始㗎啦。Ladies, gentlemen, once again, please kindly make your way to your seats as we would now commence the afternoon section. Thank you. Good afternoon, ladies and gentlemen. Once again, welcome back to the inaugural Asia-Pacific Private International Law Summit co-organized by the Department of Justice of the Hong Kong SAR of the People's Republic of China and also the International Institute for the Unification of Private Law, UNIDROIT. So now we will commence the afternoon section, and upcoming it will be the third panel section entitled Bridging the Gap in Insolvency Legal Architecture. For example, UNIDROIT's project on guidance for bank insolvency proceedings. And we're so honored to have on stage, we have Professor Tirado as a moderator for this section. A big round of applause to welcome Professor Tirado. Also, we have Ms. Tyson joining us online. Ms. Tyson, welcome. And also we have Ms. Ao Young and Mr. Lai. Big round of applause to welcome our speakers. Before I pass the stage to Professor Tirado, a gentle reminder to all our physical and online participants that we will have a Q&A section at the end of each panel section. If you have any questions, feel free to write down your questions on the question slips and pass it to our staff. You may also scan the QR code for Q&A and type your questions via the link. If you need any assistance, feel free to reach out to our staff. And for online participants, you can simply type your questions directly into the chat box and we will address them together at the Q&A section. Okay, without further ado, I can see Professor is ready now. Over to you, Professor Tirado. Please, thank you. So in this juncture, we will have 2 to 3 minutes to get ready for the upcoming panel discussion. So maybe let's have a 2 to 3 minutes break, and we'll be back in 2 or 3 minutes when everything is ready. So our physical participants and our online participants, don't worry about that. Just get ready, and we'll be back very soon. Thank you. Ladies and gentlemen, welcome back. Just a gentle reminder that the summit will be conducted in English with separate channels for simultaneous interpretation in Cantonese and in Putonghua. If you need simultaneous interpretation, please tune to channel 1 for English, channel 2 for Cantonese, and channel 3 for Putonghua. And we also have a question and answer section at the end of each panel section. So if you have any questions, do feel free to direct your questions no matter through our Q&A system or question slips or the chat box. Direct your questions to our speakers and moderator. So without further ado, I think it's now time for us to start our third panel discussion of today, which is bridging the gap in insolvency legal architecture. Without further ado, let me pass the time and also the stage to our moderator, Professor Tirado, please.
Thank you. There is a presentation that we need to, there you go. So I will let you know if we need to change the slides. Thank you. So good afternoon, everyone. Apologies for this brief interruption. I'll just spare part of the things I was going to say, so you are better off without me in that sense. The panel that we're going to be looking at now is mostly about insolvency law. Insolvency law is not, generally speaking, a part of UNIDROIT's work. UNIDROIT's work is focused exclusively on bank insolvency, which is the first part where we will be intervening. And the rest of the panelists will be speaking about other matters concerning insolvency, which do not necessarily relate to the work that UNIDROIT is doing. That is the realm of the work of our sister organization, UNCITRAL. For this panel, we have first on the UNIDROIT part and bank insolvency, we have, I will make a brief introduction, and then we'll have legal officer Mirte Tyson from Rome, who is, has woken up very early to be with us today. You can see her online, I believe. After that, Piggy Ouyang, Acting Principal Government Counsel of the Legal Enhancement and Development Office of the Department of Justice of Hong Kong, will be speaking to us about insolvency and the relationship between Hong Kong and mainland China. And then last but certainly not least, Mr. Derek Lay, the Vice Chair of Deloitte China and the global leader for the Belt and Road Initiative for Deloitte, will be speaking to us as well. On the first part, one of the things that one needs to consider always is, why are banks different to concerning insolvency? Why is it necessary for it to be an instrument which is different to ordinary corporate insolvency law for the insolvency of banks? And if you think about banks, banks are a very different type of animal in a way. Banks are an extremely risky business seen from a purely economic perspective. A bank is an institution which has its debts in the shortest possible term, meaning depositors can always recover, while they have their assets in the mid to long term, and therefore they are sitting on a ticking bomb type of gunpowder barrel, and that puts them in a very vulnerable position. This vulnerable position makes them particularly vulnerable to rumors and to hearsay and to generally market behavior. Because of this risk and because of the extraordinary functions that banks play in society, facilitating payment systems, implementing monetary policy, they are animals that require special attention. And of course, this special attention is provided for as a continuum by the supervisory service, by the post insurance. But there is the part of a bank's failure which requires also a special regulation. And it is the part of resolution and insolvency of banks that, surprisingly enough, hasn't received internationally a lot of attention, with one exception. following the 2008 crisis, the key actors everywhere, the main central banks and monetary authorities, got together in a little beautiful Swiss city from where our friend Christophe Bernasconi comes, in Basel, and developed what is known as the key attributes, which set out and lay out the main standards for bank resolution and insolvency for systemic institutions, mostly for globally systemic institutions, providing for a system which is trying to contain contagion and therefore bolster financial stability. But so much for the international effort to contain the issues raised by insolvency of banks. Apart from that, there is very little guidance as to how the insolvency of a bank, which is not as big as to be qualified as globally systemic or largely systemic, even regionally, should be dealt with. Can you move to the next slide, please? Well, anyway, whenever you can. In any case, the fact that there was sufficient regulation, sufficient standards globally for large banks, but basically a huge diversity in terms of how to deal with and to grapple with the insolvency of medium-sized to small banks, made it necessary for, or convenient for, some international organizations and international central banks to try to seek, the one after that. Yeah, okay, right. So the landscape on this was, each country has its own laws. No one really knows how to deal with the insolvency of medium to small banks, and either they apply general corporate insolvency law, which has proven, at least in several occasions, not the best solution for this type of insolvencies, for a number of reasons, amongst others because of its less nimble and agile way of dealing with problems. On the other hand, some countries had corporate law systems which were partially adapted to the bank situation, but still mostly corporate insolvency. And then there were bank-specific insolvency laws. And then amongst the countries which have bank-specific insolvency laws, there was a huge variety of solutions. Some countries worked very well, some others not so much. So there was a need for international guidance as to how to deal with the insolvency of medium to small banks. And next slide, please. And that's how, at some point, a petition arrived at UNISDRA to do work on this subject by the European Banking Institute and the government, the Central Bank of Italy. And that was a petition which we took together with the Bank of International Settlements and its Financial Stability Institute. We conducted first an assessment for the need for this type of instrument, and we conducted an exploratory workshop, the result of which was very clear. There is an absolute need to come up with best practices or standards, a guide on how to best deal with the insolvency of medium-sized and small banks. You have to think that medium-sized and small banks can be also locally or even regionally systemic. And even though they're outside the coverage of the principles of the key attributes, they still are very important and can pose, and thank you very much. This is to change the green bottom, yeah, I imagine. It can pose a challenge to local economies and financial stability, locally speaking. So our Governing Council accepted the challenge. The Bank of International Settlements was happy to join up, and we set up, following our usual methodology, a working group which includes a cross-border variety of world experts on the topic, and especially an impressive list of observers. This project is very intensely participated by the IMF, the World Bank, the Bank of China, the European Central Bank, the Federal Deposit Insurance Corporation of the United States, the Monetary Authority of Hong Kong, the Bank of Nigeria, the Central Bank of India. So it has a global dimension in terms of supervisors and regulators and resolution authorities, which makes it one of the most unique encounters of resolution and supervisors and private law experts that, to the best of my knowledge, the world has seen. So, and this is a very promising project which hopefully will result in an instrument which will be very useful globally. I will not go into much detail as to what we've done, because I did say I would spare you the time I lost myself. We have been doing quite a lot of work in this year and a half, and we still have maybe a bit more than a year to go. I would just like to, before I pass it on to Mirte Thyssen, say a bit about the topics that are being covered by this best practice instrument or document. As you can see there, it concerns basically a list of the main points that would be required to provide adequate full guidance for a country which wants to modernize its law on the insolvency of medium to small banks. For example, one of the main issues in the discussion is, since we are not talking about, by definition, large systemic banks, what should be the main objective of a law of this kind? Should it be still to protect financial stability, to contain financial stability, to make sure financial stability is upheld, or should be the maximization of value? Or are those two principles perfectly compatible so that there is actually no contradiction between them? But what if you need to apply specific rules which would normally not be available to a regulator or resolution authority concerning certain creditors, which would be then applied only in the context of the need to provide financial stability? So all these fundamental matters are being generally discussed, applied with the lens of smaller banks. And I think that is where the uniqueness of the project lays. And I think that is enough for me, and I will let Mirte take over and go on the specifics. Mirte, floor is yours. We can't hear you. You might be on mute or...
Okay, let's see, because I am unmuted. Do you hear me now?
We can hear you now, yes.
Okay, great. Thank you so much. And thank you very much for the invitation to speak today. It is really a pleasure to be there with you today, even if it's online. I would, of course, have loved to be there in person, but hopefully that can happen another time. So as Professor Tirado explained, I'm the lead officer for the bank insolvency project within UNIDROIT, and I will take over from him and tell you more about the substance of the projects and the things that we are discussing in the working group so far. Like Professor Tirado briefly explained, and I think it was on one of the previous slides as well, we're still in the process of developing the instruments. So of course, everything that we say is still under discussion, but we thought it would be good to explain what is being discussed at the moment to give you a flavor of what the final instrument will likely also look like. So if we go to the slide on the scope and definitions, we'll try, it should be the next slide. I will take over from where Professor Tirado stopped, which is, of course, one of the key questions when you start an initiative at international level, but also national level, is what is going to be the scope of the instrument? And what we take as a starting point is the framework that has been established after the global financial crisis of 2008. So when the FSB introduced its key attributes of effective resolution regimes for financial institutions, like Professor Tirado already said, that regime is focused on the largest financial institutions in the world, so globally systemic banks, but there has been less focus on what to do with the failure of small and medium-sized banks that still, because of their special nature, as has been previously explained, require a special insolvency process. They cannot just be subject to corporate insolvency law. So we are focusing exactly on those banks. So the small and medium-sized banks that to whom the newly introduced so-called bank resolution regimes would not feasibly be applicable. At the same time, the framework that we're developing can also still be applied to those systemic large banks if they are subject to what is called the resolution process and part of the bank is still going to be liquidated. So under the newly introduced resolution framework, it's possible, for example, to transfer assets and liabilities of a large systemic bank to another bank or to an asset management company or to a bridge bank. And then the resolution authority may decide that the residual entity, so that the leftover bank will be liquidated. And this part of the bank would then also still be subject to the framework that we are developing. So we are complementing essentially the framework that is already out there, that is mainly the FSB key attributes. And then, of course, on the corporate insolvency side, we're also inspired by the existing standards, for example, from UNCITRAL, that has done, of course, a lot of work on insolvency law, and also the World Bank, for example, and the IMF. So this is the scope in a general way, everything that is falling outside of bank resolution. But then the next question that the working group had to answer is, what kind of entities are we actually talking about? So we always say banks, because it was clear from the outset that we would focus on banks specifically. So we decided not to focus on insurance companies, for example. But then still, what do you mean exactly by bank? This may change, this may differ according to the definitions that jurisdictions have in place and different licensing requirements for different entities. So one of the questions that the working group discussed was, should we take an institution-focused approach towards banks or a functional approach? A functional approach would be, well, the instrument would apply to any entity that fulfills certain functions. For example, any entity that takes deposits from the public. So you would describe the functions of the entity, and all those entities that do that work would be subject to the scope of the instruments. That was one option. Another option was to take an institution-focused or regulatory approach, which is to look at which entities are licensed as banks in a certain jurisdiction, or licensed as deposit-taking institution. And this is the approach that the working group is found more convincing, also for legal certainty purposes. So at the moment, the working group is focusing on traditional banks that are licensed in a certain jurisdiction as main entities that would fall within the scope of the new framework that we are developing with the legislative guide. Another question that came up during these discussions on what kind of approach to take with respect to the scope was what to do with new types of entities that, of course, we all see are popping up everywhere. We're talking about fintechs, for example. And there we decided to keep with the regulatory approach, but to leave flexibility to jurisdictions to include such entities in the scope of this framework as well, as long as they are licensed. So jurisdictions may have different speeds or different ways of approaching these new entities, and it may be relevant and may be helpful to include them within the scope of this new framework, but it depends very much on where the jurisdiction stands. So we decided to leave flexibility to jurisdictions to decide whether to include them in the scope of the framework or not. Then, as you see in the slide as well, some work was done on definitions, which is, of course, always relevant. So we're talking about definitions, key definitions like bank, insolvency, liquidation, banking group, bank failure management, but also jurisdictions that are relevant for specific parts. So parts that I will talk later about, so cross-border aspects, for example. So what is a home jurisdiction in case of a banking group, host jurisdiction, group home jurisdiction, these kind of things. One last thing about the scope, it was decided as well, it was discussed in the working group as well, that for a banking group, it may be relevant to include within the scope not only the bank entity as such, but if you're talking about a banking group, it might be relevant as well to look at a non-bank parent company. And this is because banks are heavily interlinked, they have intragroup liabilities, for example, and it may be relevant to apply at least some parts of the framework to such non-bank parent companies as well. Next slide, please. So other topics that are being discussed in the working group by subgroup 1. So we have 3 subgroups under the working group. So everybody within the working group was given the opportunity to join one or more of these 3 subgroups. The 3 subgroups, they have been allocated specific subtopics. So each of the 3 subgroups has 4 subtopics under its remit. And these subgroups are informal, so they meet online and they do work via email, they exchange drafts. But the idea is that the subgroups develop the work of the working group during the intersessional periods. So we normally have 2 working group meetings per year, and in between those 2 meetings, the subgroups work, and we may also have additional virtual meetings on specific issues as well. So this is why you see on the slide subgroup 1 here, and subgroup 1 is in charge of the scope and definitions, but also of objectives, institutional models, and procedural and operational aspects of the liquidation procedure. I have highlighted here on the slides some of the elements that the subgroup and therefore also the working group is looking at. So for objectives, what was already highlighted by Professor Tirado before is that corporate insolvency proceedings, they normally consider value maximization as a key objective. So there is usually a court-appointed liquidator who aims to sell the remaining assets of the company that is insolvent, and with the proceeds, it pays out the creditors of the company. Well, value maximization remains important as well for bank insolvency proceedings. But at the same time, because of the special nature of banks, the working group discussed that other objectives may be relevant as well. So not only value maximization, but also objectives that have a more public interest perspective, let's say. So this can be depositor protection, because of course, one of the key categories of creditors of a bank are depositors. It's all of us. We all have bank accounts, maybe in different banks even. So that is an extra objective that can be considered. That is currently being considered by the working group. And the same is the case for financial stability. So what Professor Tirado mentioned previously as well, the whole idea behind the key attributes for systemic banks that was introduced by the Financial Stability Board was to maintain financial stability. So when a bank fails, to make sure that it doesn't have an impact on the financial stability and on the real economy. And to some extent, this also remains relevant for smaller and medium-sized banks. And it was also discussed within the working group that actually the main reason why banks are licensed, why they are supervised, is because they have this financial stability impact. They can have a systemic impact in a certain country. And therefore, this is also something to consider in the liquidation frameworks and the insolvency proceedings that we are establishing. And then some additional guiding principles that are being discussed within the working group are, for example, the need for legal certainty, but also the needs to reduce fiscal implications. So one of the main aims of the framework that was introduced after the global financial crisis was to be able to deal with failing banks without using public money, so without using taxpayers' money. And this remains, of course, relevant for smaller banks as well. So this is something that is that can be seen as a possible additional guiding principle. Well, then for the institutional models, institutional arrangements, I think that is something very interesting as well, because we see that jurisdictions have very different ways of dealing with a banking crisis, so dealing with bank insolvency. There are many jurisdictions that have a predominantly court-led procedure. So a court is in charge of the liquidation process, even for banks. And there are other jurisdictions where an administrative authority is in charge of the liquidation process. So that is more like is the case for bank resolution as well. And what we are considering and discussing within the working group is how to, of course, respect the legal tradition and institutional arrangements of each jurisdiction, but at the same time provide guidance on what might be helpful as a model to deal with bank insolvency proceedings. And one of the things that came out so far is that the involvement of relevant administrative authorities, so we're talking here about the banking supervisor, the deposit insurer, or the bank resolution authority, is especially helpful at the beginning of the process when it is decided whether a bank is failing or not. I will not go into the details of the procedural and operational aspects, also given the time that is left for me. But one of the things that was discussed during the working group is the legal standing to petition for insolvency. In some jurisdictions, any creditor can petition for the insolvency of a bank, and in other jurisdictions, this is more limited. So what is being discussed within the working group is how to deal with if there are creditors that can file for the opening of bank liquidation process, how to introduce safeguards that can maintain the financial stability. So confidentiality requirements, for example, and also the involvement of the banking supervisor. Next slide, please. So on the next slide, you see the subtopics that are dealt with by subgroup 2. I will not go into the details of this, given that I've only a few minutes left. I just wanted to mention that for the tools and powers, one of the things that the working group is discussing is the focus actually on the possibility to transfer parts of the bank's assets and liabilities to another bank or to another entity, which is something that is not so straightforward in a corporate insolvency process, where the aim or where the focus is usually more on atomistic liquidation.
Mirte, sorry to I really hate to interrupt you, but you literally have 3 minutes, so select one or two topics and I will wrap up. Thank you.
Okay, I'm so sorry about that. Then I would like to go to the slide on cross-border aspects, since the other speakers will be talking about cross-border aspects as well. I think that might then be a nice bridge to their topics. So on the cross-border aspects, 3 main things are being discussed within the working group. First, cooperation and coordination. Second, recognition and assistance. And third, safeguards. Sorry, I think it's the slide 15. So cross-border situations are important in any kind of bank, even if it's a smaller or medium-sized banks, so the size of the banks that we are talking about, because they may still have assets abroad, creditors or debtors abroad, or they may have a branch or subsidiary in another jurisdiction. So cooperation in this situation, of course, is key to ensure that there is a smooth process. And cooperation may take different forms. It may be the sharing of information. It may be coordination of the process, including, for example, if there are parallel proceedings in different jurisdictions, one of the options to consider may be to have a joint hearing or to coordinate the hearing. So to have one hearing where creditors can bring forward their claims. And another possibility that can be considered is to agree on a group solution. So once the liquidation process is opened, to have an agreement between liquidators of different jurisdictions to decide on how most efficiently to deal with the liquidation of the group. Other things being discussed are safeguards, of course, and recognition. So for the recognition of foreign proceedings, we're talking about if there is a home centralized proceeding in the home jurisdiction, then of course it's relevant for a host jurisdiction to recognize those proceedings and to be able to assist the home authorities in the actions that they want to take. And as for safeguards, I will just briefly say that one of the important safeguards is, of course, the public policy safeguard. So the ability to refuse the recognition of a foreign proceeding if this is manifestly contrary to public policy in the host jurisdiction. I will leave it to this because of the time, but I'm very happy to give further explanations or to answer any questions you may have on the project that we are currently administrating. Thank you very much.
Thank you very much, Mirte. Can you join me, please? Thank you very much. Ms. Young, it's your turn, please. Yes.
Distinguished guests, ladies and gentlemen, good afternoon, or good morning, depending on which part of the globe you are in. Thank you, Professor Tirado, for your kind introduction just now. I have a great pleasure to join you this afternoon with Matej and Derek, and also Professor Tirado, all renowned experts with immense expertise in insolvency matters, particularly in cross-border insolvency. Indeed, insolvency is never an easy subject. Perhaps it is so because insolvency inevitably denotes a certain degree of failure, and understandably, it is not a popular subject to talk about. I would, however, venture to suggest to you that resolving insolvency is very important. A predictable and efficient regime for resolving insolvency is what a sustainable economy should strive for. What does a good insolvency regime offer? It keeps viable businesses operating and prevents their premature winding up. Businesses suffering from poor management choices or a temporary economic downturn can be still turned around through reorganization procedures. If this happens, all stakeholders benefit. Creditors can recover a larger part of their investment, more employees could keep their jobs, and the network of suppliers and customers would be preserved. In the long run, access to credit will be improved and creditors are more willing to lend because they are more likely to enjoy a higher recovery rate. A mechanism for business rescues helps maintain a higher level of entrepreneurship. By facilitating the efficient exit and liquidation of non-viable businesses, an optimal insolvency framework supports the efficient reallocation of resources across the economy. The setting up of a good local insolvency regime is, however, no longer good enough. We are now in a truly global economy sculpted by digital transformation and the generation of complex corporate structures stretching to multiple jurisdictions, thereby facilitating the conduct of businesses not so much across the border, but more precisely without any borders at all. We are increasingly witnessing larger insolvencies which invariably have at least certain elements of cross-border nature. At the international level, as helpfully remarked by Matej just now, particular focus has been put on various tools and protocols to address cross-border insolvency matters, including Eurodra's very important project on bank insolvency and other instruments like the relevant model laws. Speaking of the presence of cross-border elements, there is no better example than that of Hong Kong. Hong Kong is part of the People's Republic of China. Under the principle of one country, two systems, Hong Kong is part of China, and at the same time, we retain our own way of life and own systems. Hong Kong's legal and judicial system is separate from that of the mainland China. The Basic Law, Hong Kong's constitutional document, gives legal effect to one country, two systems. The Basic Law guarantees the continuation of the common law system that has been practiced in Hong Kong for over 170 years. The application of the common law in Hong Kong is as robust as ever, with our court rulings being applied in other common law jurisdictions. Indeed, Hong Kong's common law system with an independent judiciary has often been understood, and quite rightly so, by foreign investors and businesses as providing efficiency in the law, better contract enforcement, and more market-oriented regulations. The amount of cross-border commercial activities between Hong Kong and the mainland China has grown significantly in recent decades. Some figures may help shed the light in the big picture. Hong Kong is the mainland's largest source of foreign direct investment, accounting for over 50% of the national total. And last year, companies from the mainland China listed on Hong Kong Stock Exchange accounted for over 70% of the exchange's market capitalization. The increasingly closer social and economic ties between Hong Kong and the mainland China has certainly given rise to many success stories. Inevitably, however, some businesses have failed or experienced financial difficulties, and they need assistance to resolve them. The issues that arise when businesses fail feature complications resulting from the fact that Hong Kong and mainland China have different legal and regulatory systems. In very broad terms, cross-boundary insolvency issues in the context of Hong Kong can be categorized into two folds. First, those involving businesses operated by companies incorporated in a foreign jurisdiction, such as offshore jurisdictions like the BVI, the Bermuda, or the Cayman Islands. And secondly, those in which a substantial proportion of the business's assets are located in the mainland China. May the truth be told, in very many cases, the issues come within both categories. Hong Kong at present does not have any statutory provisions providing for cross-border insolvencies. Some critics may view that Hong Kong's lack of a statutory regime in this area would be a drawback. While there might be some force in this contention, the apparent deficiency has in fact planted the seeds for vibrant development of common law principles, whereby we have developed mechanisms and practices enabling our courts to recognize and assist non-Hong Kong insolvency proceedings at the request of non-Hong Kong courts. Hong Kong courts have notably, by way of common law, recognized mainland insolvency proceedings and granted assistance to mainland insolvency office holders. To this, I would refer you to the decision of the Hong Kong Court of First Instance and CEFC Shanghai and Shenzhen Average. In both cases, the Hong Kong court, on the strength of letters of request issued by the mainland courts, made orders recognizing that the administrators had been appointed by the respective mainland courts, and as a consequence, they were the authorized representatives of the companies in Hong Kong. The orders included express powers to allow the mainland administrators to take certain actions in Hong Kong to progress the liquidation of the companies. Such actions include, for example, taking control and taking possession of the company's assets in Hong Kong. While the application of the common law powers by the Hong Kong courts has been instrumental, there had been, however, no specific legal basis for the mainland court's recognition of and assistance to Hong Kong's insolvency proceedings. This was so until May last year, when the Hong Kong government entered into a record of meeting with the Supreme People's Court, whereby a new mechanism was born. What is offered by this new mechanism? In very simple terms, it is a significant breakthrough that Hong Kong liquidators and professional liquidators now have access to mainland courts. They may apply to mainland courts in the current 3 pilot areas, namely Shanghai, Shenzhen, and Xiamen, for recognition of insolvency and debt restructuring proceedings in Hong Kong, and also for assistance to perform their duties in the mainland, such as the taking over of the debtor's property in the mainland, investigating into the financial position of the debtor, or participating in legal actions or arbitrations on behalf of the debtor. And on the other hand, the Hong Kong court has continued to recognize orders made by mainland courts in bankruptcy and reorganization procedures and grant assistance to mainland administrators pursuant to the common law mechanism. The cooperation mechanism between Hong Kong and the mainland, very importantly, features debt restructuring using a scheme of arrangement sanctioned by the Hong Kong court. Before the mechanism, there had been no legal framework which facilitates coordinated and court-supervised approach in debt restructuring for both Hong Kong and mainland. This is no longer the case, because of the mechanism now provides such a mechanism. The express coverage of debt restructuring through schemes of arrangement arguably offers a higher degree of certainty compared to the model law on cross-border insolvency. This is of particular relevance to Hong Kong. Why? Because Hong Kong, as discussed moments ago, the destination where international businesses raise capital. With the mechanism in place, Hong Kong has further strengthened our competitive advantages as a one-stop shop, from financing to trading and to restructuring. By now, Hong Kong remains the only jurisdiction which has established with mainland a cooperation mechanism for corporate insolvency and restructuring. This is nothing but a strong testimony to the vitality and unique advantages of the principle of one country and two systems. Hong Kong, being the only common law jurisdiction within China, is privileged to perform the role of a testing ground and support mainland China's further deepening of judicial and legal cooperation, particularly in areas like corporate insolvency, which often raise complex and legal issues. The establishment of the cooperation mechanism also demonstrates the weaving of innovative solutions into the fabrics of one country, two systems, so as to effectively address the challenges brought by the development of Hong Kong in our unique role as a principal international financial center through which mainland businesses have raised foreign capital and foreign debts. The mechanism also positively drives the development of common law in Hong Kong. The Hong Kong insolvency proceedings to which the mechanism applies are the proceedings in respect of companies whose center of main interest, COMI for short, has been located in Hong Kong for 6 months prior to the application for recognition and assistance. This takes into account the very fact that many companies operating in Hong Kong are currently incorporated in foreign jurisdictions. However, their COMI may well be in Hong Kong, particularly if they are listed on Hong Kong Stock Exchange. It seems evident that common law in Hong Kong is moving towards recognition that a company's COMI is an important consideration when the court is being asked to consider exercising its jurisdiction over a company incorporated elsewhere, as can be seen from the recent decisions of the Hong Kong court in Lamtex and Global Brands. This move would, of course, be in line with the principle of modified universalism as reflected in various international instruments, including the model laws. In terms of the implementation of the mechanism, I'm most pleased to report that there has already been a case in which the Hong Kong court has issued a letter of request to the Shenzhen court. And a few months later, pursuant to the mechanism, the Shenzhen court recognized the relevant Hong Kong proceedings and the liquidators appointed therein. I'm sure Derek would, in a minute, discuss and share more about these interesting stories, as well as his first-hand experience on issues relating to COMI arising from the application of the mechanism. The mechanism has vividly exhibited the advantages of common law regime, being what? Efficient, flexible, and case-specific. Indeed, there's a great deal to be said for allowing judges to develop the law on a case-by-case basis, in that it relies on experience and it should be flexible and responsive. But admittedly, such a system does have its own limits, particularly in an age when detailed laws and regulations are thought to be appropriate in many areas. In the context of dealing with cross-border insolvency, while the tool of common law recognition and assistance has proved itself to be effective and efficient in appropriate cases, there are bound to be other circumstances where the limited common law powers would not be sufficient, nor appropriate, but a full scale of ancillary winding up in Hong Kong of a non-Hong Kong company would still be warranted. So down the road, it would be most worthwhile to actively study the need for a statutory regime, preferably along the line of the model law. After all, an express statutory regime would invariably offer added certainty and predictability, something as aptly pointed out by Professor Tirado in his opening address this morning, as something fundamental, being the fundamental core objective of UNIDROIT's work. I'm sure certainty is universally welcome, creditors, investors, and debtors alike. In relation to the Hong Kong and mainland context, we would certainly remain optimistic that stakeholders from both sides, including administrators, lawyers, and judges, would take time to work out how best to make full use of the mechanism, including to encourage cross-boundary debt restructuring, thereby avoiding insolvency and avoiding unemployment. At the moment, the mechanism does not extend to all parts of China. The Department of Justice will continue to support stakeholders from both sides to contribute wisdom and all forms of nutrients to the mechanism. And efforts would be made in due course at an appropriate time to seek the extension of the mechanism to geographical application, to extend it to other parts of China. I hope that by now we would all approach the subject of insolvency, and indeed cross-border insolvency, with more hope and optimism, but not just doom and gloom. In the context of Hong Kong and mainland, we have witnessed the cooperation mechanism, how effective solutions in line with international standard and international development could be created out of the agility and responsiveness offered by the common law regime practiced in Hong Kong, further displaying the usefulness and success of the principle of one country, two systems. This very much echoes President Xi Jinping's address delivered a few months ago, celebrating the 25th anniversary of the establishment of the Hong Kong SAR, in which President Xi has expressed an acknowledgement in maintaining Hong Kong's unique advantages under the common law system, and the support of the central government in Hong Kong's effort to maintain our distinctive status, keeping the business environment free, vibrant, and effectively regulated. On this note, may I conclude by wishing the summit and the rest of the events in the legal week every success, and to our guests from the overseas, a wonderful stay in Hong Kong. Thank you.
Thank you very much for this excellent presentation and sharp on time. Mr. Lei, the floor is yours.
Thank you. Before I start, can I ask the screen to be changed to the PowerPoint? Thank you. First of all, good afternoon, ladies and gentlemen. I would like to take this opportunity to thank Honorable Paul Lam, Peggy, and DOJ inviting me to speak in this legal week. All along, I think this is a very hot topic that the liquidators in Hong Kong have difficulties for exercising their powers in the PRC. And so this topic I'm looking into is actually the corporate mechanism for mutual recognition and assistance to insolvency proceedings between courts of the mainland and Hong Kong. And I would like to thank you for DOJ taking the initiative to one step forward to discuss and work together with the PRC courts to have this done. This is the first very successful step. And I'm not going to repeat what Maggie has mentioned, but obviously this is writing on the basic law to have this cooperation mechanism to be formulated, and mainly in three pilot mainland areas: Shenzhen, Xiamen, and Shanghai. But one thing I would like to highlight here is that it's not just the Hong Kong liquidator going to be recognized in the PRC, but also PRC bankruptcy administrators can apply to the court to be recognized in Hong Kong. Although in the past, so far there were only 4 cases applying in Hong Kong and go into the PRC to recognize the liquidator's power, no cases had so far submitted to Hong Kong under this cooperation mechanism for insolvency proceedings by PRC administrator. But having said that, there was one case, as Peggy has also mentioned, it's the HNA Company Limited. Justice Harris has, under the private international law, which is a part of the common law, recognized the administrator of HNA Company Limited in Hong Kong. The reason is because Justice Harris believed that the bankruptcy is under collective insolvency process, and also the administrators were appointed in the PRC, and the business of HNA were also in the PRC with the center of main interest in the PRC. So he recognized the administrator in Hong Kong, but not under the cooperation mechanism for insolvency process yet at that time. The Supreme People Court actually issued a guiding opinion, very detailed, with around 16 pages bilingual, while Hong Kong DOJ has issued practical guideline, and it's much simpler. It's around 1.5 pages, so which is to facilitate the PRC bankruptcy administrators to come to Hong Kong and to recognize them. And there are only 3 major steps in Hong Kong if PRC bankruptcy administrators come to Hong Kong, basically. One is they need to apply a letter of request in PRC, and then they need to apply to Hong Kong court by way of an ex parte hearing, and then court hearing can be done by paper or by a formal hearing. So this is very simple in Hong Kong. So I believe, moving on, it is quite possible that there will be more and more PRC administrators would come to Hong Kong to recognize their powers. Today, I'm going to talk about 3 cases. So far, as I mentioned, there are only 4 cases applied for the letter of request successfully, and we were the liquidators of 3 cases, 3 of the 4 cases. The first one is Samsung Paper, and this is a company incorporated in Hong Kong and involved in trading paper products, property investment in Hong Kong, and with a number of subsidiaries in mainland. And the company was placed into creditors' voluntary liquidation, not court liquidation, I would like to highlight to you. And then the assets of this company basically would be including subsidiaries in Shanghai, Shenzhen, and then some receivables in mainland, and also Beijing property. And the Hong Kong company in this case is holding all these assets directly themselves instead of through a movie. Now, today my PowerPoint is quite in detail, so it's to facilitate you to read it in your leisure. But I'm not going through step by step in light of the time. But if you look at the timeline here, you will notice that it took around 5.5 months for the whole process to be completed. And this is something that we should also look into as well, because the purpose of recognizing liquidators is to try to avoid some companies, directors, to stop the Hong Kong liquidators in realizing the assets for the benefit of general body of creditors in Hong Kong. So if it is take too long to recognize liquidators in the PRC, that means it is giving chance for the company directors to dissipate the assets in the PRC. So this is something that we should look into as well. And the risk of dissipation of assets will become higher. So in this case, we didn't go through PRC lawyers to do this. We did that ourselves with the Shenzhen court. And it was very lucky that we got Shenzhen court's agreement and granted various power, including taking over the books and records, company seals, settlement expenses of, and also managing the company's assets, and also disposing the company's assets as well. But there are also some powers that we still need to go back to Shenzhen court to ask for their approval. This will be including like borrowing money, transferring money out from PRC into Hong Kong or overseas, and also if we take any actions that may have significant impact on the creditors in the PRC, then we need approval from the People's Court as well. So obviously the court has concerned how much social impact we will be making in the PRC. So in this case, you can see that very simple in Hong Kong process is Justice Harris consider whether this is a Hong Kong court jurisdiction, whether Comey is in Hong Kong, and whether it's a matter of justice to give the letter of request. But in the PRC, you would see that other than Comey, whether also Samson Paper has assets in the PRC, they are looking into one main area, which is the Hong Kong insolvency proceeding, if it is in line with the enterprise bankruptcy law in the PRC. Now, that in other words, that means whether the power of the liquidators in Hong Kong, when we move into the PRC, would we have more than the powers that normally grant to the PRC bankruptcy administrators? And whether the asset disposal or dividend distribution is in line with the PRC law, and also whether treatment of creditors and employees are in line with the law in the PRC. So they would also look into what actions we are going to do after we take over the assets of the company, and whether this will create any negative impact, and if yes, what are these impacts, and etc. Now, if you go into the second case, which is what we are handling as well, it's called Osner Water. It is a listed company in Hong Kong. Very interestingly, this is not a company incorporated in Hong Kong, but Justice Harris also regards this as Comey is in Hong Kong because the management of the Osner, of the company, is basically in Hong Kong as well. Now, these are the major assets of Osner in PRC. Okay, this is directly owned by Osner instead of through a movie. Okay, so one is the judgment debt of 20 million, and the other are the two claims. We haven't got the judgment debt yet, but two claims also due by the same debtor, and in a total of 142 million Hong Kong dollar. So, so we believe that it is important for us to be recognized in the PRC. But as I've mentioned earlier, after Justice Harris considered that the Comey is in Hong Kong and granted a letter of request to us, he believed and emphasized that without the assistance in the PRC, it is more difficult for us to collect the debts in the PRC. Okay? So in this case, we noticed that when we were applying to the Shenzhen court, we noticed the judge who granted the order in Samson Paper has moved on to another new role. So to play safe, we tried to ask informally the Shenzhen court what will happen and what further information they may require from us. And we talked to a new judge assistant in Shenzhen, and it appears that the assistants have a little bit negative concern because they feel that, okay, whether Osner's principal assets are in Shenzhen, and whether Osner has office in Shenzhen, okay? Now, as I mentioned earlier, there is a judgment debt of 20 million. Okay, this is to the Hong Kong liquidators. This amount is not a small amount. I'm sure certainly the creditors in Hong Kong would not regard this as a small amount of money. And I have not even mentioned about the claim of 142 million as well. So these are very important assets if we can realize from Shenzhen debtor. At the same time, the insistence of the new judge also asked, okay, whether the Shenzhen debtor, they have a bank account in mainland, and how much was the bank balance in it? And we discovered that the bank balance was quite small. It's around 20,000 renminbi. And we also noticed that the Shenzhen debtor has shares in various private-owned companies in the PRC. Now, because these are minority shareholders, minority shares, so we could not obtain sufficient information about the value of these shares in the PRC as well. So the assistant of the new judge mentioned that in his view, the judgment that can be realized by enforcement in the PRC court. So, and also at the same time, Osner has no other assets and also no office or employees in Shenzhen. And so we don't need to apply for mutual recognition in the PRC. But of course, as I've mentioned, 142 million adding into the 20 million, a judgment debt is 162 million is not a small amount of money. And in particular, 2 days ago, we got another 50 million judgment debt. So we are going to consider what we should do with our lawyers to see whether we should continue to go ahead with the Shenzhen recognition, and I will report this to you sooner or later. The last case I would like to talk about is the freshwater case, Hong Kong Freshwater. Hong Kong Freshwater is a Hong Kong company which is also a subsidiary of Osner. And they have around 4 subsidiaries, wholly owned subsidiary in Shanghai. And Freshwater is in Hong Kong compulsory winding up. And if you look at the assets, you will see that these 4 subsidiaries are mainly in environmental technology related business. So we consider, again, we want to control these 4 companies, and so we apply to the Shanghai court for the mutual recognition. So we obtained letter of request from Justice Harris, but prior to the delivery of the letter of request, we talked to the Shanghai court, and because before the formal hearing, we want to know what further information they may need so that we can be well prepared. And the Shanghai court told us that all the creditors, including onshore and offshore creditors, should be notified of the application of recognition and the date of hearing, and so that the court in the PRC can see whether they have any comments. So it was decided that the PRC court would notify the onshore creditors by advertising in their newsletter, and the liquidators in Hong Kong are required to notify the offshore creditors in Hong Kong. Now, only 7 days was allowed to be given, okay, for the creditors to support or oppose. And in Hong Kong, there are basically 3 creditors. One is the Hong Kong government agency, and the other one is a bank, and the last one is Osner Water, which is the listed company in Hong Kong, of which we are also the liquidators as well. And we noticed that the government agency, they didn't reply to us within 7 days, but the bank and ourselves, of course, provide our support to the recognitions application as well. So finally, the hearing was taken place on 14th of October, last month, basically. And we noticed that, again, one onshore creditor who was holding a guarantee of 150 million due by a related company of Freshwater, requests a further 15 days to enable them to consider whether they should support or oppose or to provide any comments. 15 days have already passed, and we noticed that no comments were given by them. And also, interestingly, at the same time, we noticed that the guarantee was not registered in the PRC. So now we are waiting to hear the judgment from the court in the PRC. After the hearing of our application, the PRC Shanghai court asked for a copy of the latest management account of freshwater in Hong Kong. And actually, we did provide management account, which means unaudited accounts, up to the end of June 2020. And bearing in mind, the company, Freshwater, was only wound up in March by the Hong Kong court, 2021. And if you go back to the petition for winding up date, the petitioning date was only in December. So there was no management accounts prepared within those short period of time. And at the same time, the Shanghai court also asked for a list of creditors, including onshore and offshore, which we did provide. And then they also asked for the liquidators to give them an opinion, okay, what will be the next steps that we would do? Obviously, the court again is considering what will be the implications if we take over the subsidiaries, and how will that affect the subsidiaries and the creditors in the PRC. So, of course, we haven't got the judgment yet, but hopefully we can get a favorable judgment moving on. Now, from all the three cases, we noticed that there are a few limitations so far. And of course, this is a very initial implementation, and we need to look into the execution and implementation of each case, and then so as to improve the law. Now, the first limitation we see that is the number of pilot cities, only 3 cities, okay? And it's applied very strictly. That means if you have assets in Quanzhou, which is close to Xiamen, but you don't have assets in Xiamen, they would not allow you to apply in Xiamen. The second limitation we see that is it is very common for Hong Kong companies holding through PRC assets through a WUFI. So that means that Hong Kong companies may be just holding the shares of this WUFI. And in a lot of situations, we have difficulties in obtaining the management accounts of this WUFI or the financial information. So would that be regarded as substantial assets by the PRC court? That is another question. Now, the third limitation is that it is only applied to insolvency proceedings like court winding up, creditors' foreign liquidation, scheme of arrangement, and maybe some restructuring. But it doesn't apply to light touch liquidators, receiverships, and etc. Point 4 is that you will see from the example earlier that the PRC court has very, very major influence in the decisions. And it will be arguable in some cases whether they should not or they should give the order recognizing the liquidators in Hong Kong. The last limitation is the timing, because as I've mentioned earlier, we need quick enough time to allow us to control the assets in the PRC so as to protect the creditors' interests. So this is something that we need to look into as well, including how to help the creditors by using the mutual recognitions. So our suggestions here is extend the pilot cities moving on to outside, at least go to the Greater Bay Area, expand the scope to cover light touch provision liquidators, court appoint receivers, and also consider the definitions of assets in the PRC. Would that include intangible assets as well? And the last one is we probably need to look into the practical guidelines in terms of execution, in particular in the PRC, so as to give us more clearance before we spend a lot of effort and time in applying to the Hong Kong court and the PRC court in exercising our, applying for the mutual recognition of liquidators in Hong Kong. So this also aligned with the record of meetings signed by the former Secretary for Justice and also the Vice President of Supreme People's Court, that the implementation is very important. And DOJ has also mentioned that we need to explore rules of governing these cross-border insolvency. And we need to continue to keep very closely communications cross-border between the two court systems to improve this mutual recognition mechanism. So this is my presentation today, and I'm happy to answer any questions. Thank you.
Thank you very much. Thank you very much for both of these very rich presentations on a subject matter which is extremely valuable to those of us who don't speak Chinese, and therefore very difficult for us to access this type of information abroad. So it's extremely important, and I would encourage you, if you haven't done so, to publish this type of presentations, because abroad they would have a lot of importance. There are a number of questions. I'm not sure I'm reading them correctly because they stop after a few words, so I can't really read the whole question, but I'm going to ask a question to each of you. I think we have the time, and we started a bit late. So first question I would ask perhaps to Ms. Ouyang. So if you draw from the experience of other areas, and for example, to take the application of the cross-border model law of ancestral, which is the standard on the topic, or what happened in the European Union with the EU regulation, both of which are based on the concept of the center of main interest, that allows the market to some degree of forum shopping, meaning you choose one forum over the other. And there are two reasons for forum shopping. One of them is because the legal framework of one of the places is preferred to the other. And another one is because the institutions of one country are deemed more efficient than those of another. So just picking an example, might it be possible perhaps that looking at foreign experience, at some point companies from mainland China might want to transfer their COMI to Hong Kong to be restructured here, especially if you are going to be applying restructuring schemes of arrangement and things of the sort? Because let's say, and I wouldn't know, Hong Kong's system is more well known, especially companies which have foreign investment. That would be a question for you. If you don't mind, I'll ask all the three questions and then you'll take it in turns. In the case of Mr. Lei, my question would be your opinion on a relatively different topic. In case of bank insolvencies, my understanding is that mainland China doesn't have a fully established open cross-border regime for the recognition of resolution measures in mainland China. So if a foreign bank which has subsidiaries in China or has operations in China is declared an insolvency we're talking about a bank in a foreign jurisdiction, and it wants to implement measures in mainland China, unless there is a bilateral agreement with that country, there's no certainty of implementation of the measure. There have been cases like the Lehman subsidiary where my understanding is that the resolution measure of a foreign country was implemented in mainland China because there wasn't a bilateral agreement, but otherwise it might not have been the case. And I wonder if that is, in your opinion, something which would be different in the case of Hong Kong. So if the resolution measure adopted in a foreign country were to be implemented in Hong Kong instead of in mainland China, if there would be a different result. And the third question to Mirte, which comes from the public, is how are we dealing with the treatment of the priority of depositors, depositor protection in the bank insolvency case? Let's answer in this order, if that's okay.
Thank you, Professor Tirado, and thank you for the very interesting questions. I'd like to attempt the first one about COMI and its impact for the cooperation mechanism between Hong Kong and the mainland. Yes, indeed, we are moving towards COMI, and in fact, for the purpose of the cooperation mechanism, it is stipulated in clear terms in the practical opinion issued by the Supreme People's Court that those companies applicable for recognition and assistance under the cooperation mechanism would be those companies whose COMI is in Hong Kong for the 6 months prior to the application for recognition and assistance. So there is a certain period here to avoid, to a certain extent, purely or merely forum shopping. So it has to be here for a substantial period of time. And of course, it's always a balance. In Hong Kong, we have a very special structure. We have many companies in Hong Kong which are not incorporated here. As I have explained, we have many companies listed on Hong Kong Stock Exchange whose places of incorporation are in the offshore jurisdictions like the BVI, the Bermuda. So this is a very special structure. Perhaps not so unique to Hong Kong, but very special in a way. For determination of the COMI for the purpose of the mechanism, the place of incorporation is the starting point. So the mainland court will look at where the company is incorporated. So if it is a Hong Kong company, it's definitely a tick. If it's not a full stop there. So the applications, the applicants, the liquidators, or the provisional liquidators for debt restructuring purposes, they could prove to the mainland court that despite the fact that the company is not incorporated in Hong Kong, its COMI is still in Hong Kong by illustrating a few factors, including its principal place of business, its principal place of office, and its principal place of assets. So all these factors as a whole would help prove the company's COMI for the purpose of the cooperation mechanism. And also, as far as I understand, under the model law, for example, the ancestral model law, they also have definitely the concept of COMI. And for the purpose of model law, the center would apparently be the central administration of the debtor, and which is readily ascertainable by the creditor. So, and also a basket of factors to help illustrate or to prove that. So I think for the purpose of the mechanism, we are moving towards that. And of course, down the road, we would be hoping to see more practical cases from the practitioners, and also some feedback from practitioners, so as to how we move forward and how best to make use of the mechanism. So that is my response, if it helps. Thank you.
Thank you. First of all, Professor Tirado, I forgot to apologize at the beginning that I didn't stand up to give the speech because I just finished my spine operation and I came out from hospital yesterday. So it was, I'm a Christian, it's a glory to God that I can sit here to give the speech. Going back to your first questions to supplement what Peggy said, Osna Water was actually incorporated in Cayman, and also Judge Harris also granted the order on the basis that the COMI was in Hong Kong because the management of the listed company was in Hong Kong and the people were in Hong Kong doing the other operation. Going back to the second questions well, I'm not because you would appreciate Hong Kong MA is very good in supervising the banks in Hong Kong. So far, not many cases of bank insolvency. But especially if you are talking about overseas bank with operation in the PRC. Now, in a lot of situations that I work on BCCI in the PRC on the liquidations, and a lot of situations, they also hold assets through WUFI, as I've mentioned, the wholly owned subsidiaries in the PRC. So the WUFI obviously have to follow the PRC law when it's going into insolvency. And I'm sure if they have a banking license, then the People's Bank of China would have a big say in that regard, especially bearing in mind social stability is the major concern of the PRC. And so far, I didn't see there are so many cases yet, but I believe that we have to follow the law in the PRC in order to stabilize the situation and also to follow what the governments want. I don't think the foreign laws will be applicable there in that regard. Yeah, I hope I answer your question in that.
Thank you. Well, the question was more: would you apply a resolution measure in China or in Hong Kong, which was it's not about applying a foreign law, but rather applying a decision of a resolution authority, which would require, for example, the sale of assets here?
I don't think so yet as well. But well, I think China has its own scheme of resolution in the PRC, how to, like, for example, stabilize the situations and how to help the banks and etc. So, but not necessarily using the offshore legal system on resolutions. Yeah.
Thank you very much, Mirte. And we finish here with you. Yep.
Yes, thank you very much. And I thank the person who made this question. I think it's a very relevant question, of course. So the working group has considered this issue in various different ways. First of all, I would like to clarify that as for the creditor ranking as such, or creditor hierarchy, the work that we are conducting is not seeking to establish an absolute harmonization of a creditor hierarchy. Of course, this would be not feasible. What the working group is doing is looking at the relative ranking of certain types of claims. And then specifically, we're looking at depositor claims, but also intergroup liabilities, for example, and the claims of secured creditors. But what we're not aiming to do is to establish a harmonized creditor hierarchy for bank insolvencies. So having said that, now to go into the question on how the treatment of depositors or creditors is dealt with in cross-border bank insolvency proceedings or under the framework that we are envisaging. This is in several different ways. So in the work that is being done on cross-border aspects, one of the things that is being considered to recommend is that the process is fair and efficient. And this implies also that home and host authorities should take into account all stakeholders' interests, including those of foreign parties that should not be discriminated against. So this is a general principle of non-discrimination, let's say. Then the second way in which it is taken into account is that in the grounds for refusal that I didn't manage to go into the details before, but one of the grounds for refusal that is being considered is the sorry, do you hear me correctly?
Yes, we can hear you well.
Okay. I saw that the screen was still. One of the grounds to refuse recognition would be if this would be manifestly contrary to the public policy of the state, and specifically the refusal on this basis would be justified where the competent authority discriminates against creditors on the basis of their nationality, the location of their claim, or the jurisdiction where it is payable. So again, this could be an element where you would take into account the treatment of creditors in a different jurisdiction. Another recommendation that is being considered by the working group is that in granting, denying, modifying, or terminating relief, the competent authority should satisfy that the interests of the stakeholders, including deposit holders, are adequately protected. This adequate protection does not mean that the bank insolvency laws and the creditor ranking should be identical. Rather, it refers to the local priorities of and the rights of stakeholders. And if, because of such special rights, creditors are worse off by participating in a centralized home proceeding, then the recognition might be conditioned by a requirement to compensate or to take account of the special priority within that home process. So then there will be the possibility to take into account the priority granted under the host jurisdiction, even if there is a centralized proceeding in the home jurisdiction. And then the last way in which this is taken into account is on a recommendation that is being considered by the working group on the undertaking of the treatment of foreign claims. So in the general, we generally try to encourage jurisdictions to facilitate centralized home liquidation proceedings. But if there are, it may be necessary that a claim brought by a creditor of an entity in a host jurisdiction may be treated in accordance with the treatment granted under the host jurisdiction. So this is in line with what I described before. There are possibilities to have the claim be treated under the laws of the host jurisdiction, even if there's a centralized proceeding in the home jurisdiction.
Thank you,
I
Mette.
hope that clarifies. Thank you.
Yeah, thank you very much. Well, it only remains for me to ask everyone, please, to thank the panelists for their excellent presentations.
Thank you. Thank you so much, Professor Tirado and our speakers. Please remain seated. And Ms. Tyson, also please keep your smile and look into the camera, and we would like to capture this moment. So our official photographer is right in front of the screen to capture this moment. Ms. Tyson, we can see your perfect smile indeed. And once again, ladies and gentlemen, please give a big round of applause to Professor Tirado, Ms. Tyson, Ms. Aoyang, and Mr. Lai. Thank you so much. Thank you. Thank you. So ladies and gentlemen, we'll now have a 10 minutes break. Please enjoy the refreshments in the designated area outside the conference room. And remember, please come back in 10 minutes. For our online participants, you don't need to log out. Just come back in 10 minutes and we'll be back very soon. See you in a bit. Thank you. Ladies and gentlemen, good afternoon. Our final panel section of today will commence shortly, so please make your way back to the hall. And a gentle reminder, please kindly switch your mobile phones or any electronic devices to silent mode. Thank you. 咁多位嘉賓，我哋今日啦最後一個專題討論環節啦，即將開始啦。所以我哋有請咁多位嘉賓立即啦移步翻嚟我哋主會堂嘅呢一個位置啦。接住落嚟啦，等我哋一齊啦去欣賞啦，同埋參與今日最後一個環節嘅。多謝咁多位。Good afternoon, ladies and gentlemen. Welcome back to the afternoon section of today's summit. Upcoming on stage, we're going to have the fourth panel section titled Into the Future, Strengthening Engagement in the Asia-Pacific Region. We're delighted to have a distinguished panels on stage, and let me introduce them to all of you. First, we have Dr. James Ding, Law Officer, International Law, Department of Justice of the Government of the Hong Kong Special Administrative Region of the People's Republic of China, and also Chair of the APEC Economic Committee. So a big round of applause to welcome Dr. Ding as a moderator. And joining Dr. Ding on stage, we have three speakers. They are Mr. Bridie Watson, Professor Chow, and Mr. Lee. A big round of applause to welcome our speakers too. Without further ado, I'll pass the stage and the time to Dr. Ding to start our thought-provoking section. Dr. Ding, over to you.
Thank you. We are coming to the last sessions of today's summit. We find this summit very informative and very exciting, actually. I talked with some participants over the break, and we all find this summit very useful, and the sessions really insightful. We are now coming to the last panel of this today's summit, and we have representatives from all the three sister organizations here on this panel, and I think this is the only panel with all the panelists in person here. So it's really our privilege to have the all in-person very strong panel. We have representatives from the UNIDROIT, Hague Conference, and UNCITRAL. This panel is forward-looking. We have heard a lot about what UNIDROIT or what the developments of private international law this morning and this afternoon. And for these sessions, we focus on the topic on how to strengthen engagement in the Asia-Pacific. Asia-Pacific is huge. There are many different legal systems, many different countries, many different legal systems in Asia-Pacific. We have civil law, we have common law, and extraordinary law. But for these three international organizations, it seems that the memberships in Asia-Pacific is still rather limited. So there's still a lot of work to do for these organizations in Asia-Pacific. There are many ways of strengthening the engagement of the Asia-Pacific. One of the ways is to go through or do work together with some regional organizations. For example, in this region, ASEAN and APEC. In my another hat as the chair of the APEC Economic Committee, we welcome the three sister organizations, UNIDROIT, Hague Conference, and UNCITRAL as accredited guest member of the APEC Economic Committee, and we welcome their contributions to the work of APEC. On Wednesday, we also have an ASEAN workshop which we collaborate with the ASEAN Secretariat, and that's also one possible way that we can work together with these international organizations. And I think that all the organizations representatives will also be present on Wednesday as well. There are also many other ways on how to strengthen engagements in Asia Pacific, and I will leave that to our three distinguished panelists. So without further ado, may I first invite Will Bidey Watson, the Senior Legal Officer of UNIDROIT, and he will speak from the UNIDROIT perspective. Will, please.
Thank you, and good afternoon, everyone. It's my pleasure to speak to you again, this time about a much less legally substantive presentation, but nonetheless still very important. So over the last 4.5 hours, over the last 3 sessions, we've spent a lot of time looking at some of UNIDROIT's and our sister organisations' most important instruments that can assist legal harmonisation across the Asia-Pacific. But of course, no matter how good the instrument is, if no one is aware of it, if no one is implementing it, if no one is using it, it's not working. So this is why UNIDROIT is very pleased that for this last panel today, we're talking about engagement with this region to ensure that the countries in this diverse area of the world are all getting the most they can out of the international standard instruments produced by UNIDROIT, the Hague Conference, and UNCITRAL. So today my presentation takes 2 parts. First is going to be a self-assessment of where UNIDROIT is up to in its engagement with Asia Pacific. And the second part, as James mentioned, is going to be forward-looking. It's about what strategies we're trying to use to try to increase our engagement with this region and improve awareness and utilisation of our instruments. So in trying to self-assess where we're up to as an organisation, I looked at 4 criteria. 1, of course, UNIDROIT membership, how many member states we have in the region, and as a second part of that, representation on our governing council, our peak body. 2, ratification and implementation of our instruments, of course, another obvious metric. 3, government and expert participation in our projects, whether Asian and Pacific experts are actually engaging in the negotiation of instruments. And 4, some non-legislative metrics, which I'll go through quickly. So here is UNIDROIT's global membership. We have 63 member states covering 73% of the world population and 90% of global nominal GDP, which on that map looks quite nice. However, when you look at this region, it's clear that we are underrepresented in the Asia-Pacific region. We only have 10 member states in this area, and we only have 3 governing council members from Asia Pacific, which is more or less reflective of our membership, because our governing council is made up of 25 experts selected from different states. So if we have 10 Asia Pacific members and 3 governing council members, that ratio is about correct. But the problem is we don't have enough member states. So there's no doubt that UNIDROIT needs to improve levels of membership in Asia Pacific. So on that metric, we're not doing that well. Conversely, in relation to some of our conventions, we're doing very well. So despite only having 10 member states in the Asia Pacific, of the Cape Town Convention, there are 25 contracting states to the Cape Town Convention and to the aircraft protocol in this region, which indicates that there's been a lot of interest in our work here, even if not membership. Similarly, our 1995 Convention on Stolen and Illegally Exported Cultural Objects, which is our second most successful treaty law instrument, also has 11 contracting states in the Asia-Pacific region, 1 more than our member states. So on this metric, we're actually doing better than we are in the membership metric. Looking at the development and the actual negotiation of instruments, once again, we're actually relatively proud of the current participation of Asia-Pacific experts in the negotiation of our instruments. So if you look at here, I've got the 6 current high priority legal instruments that we're currently negotiating. So these are works in progress that we haven't yet finished. bank insolvency, digital assets, effective enforcement, model law and factoring, model law and warehouse receipts, and legal structure of agricultural enterprises. These are all instruments that we're in the process of negotiating. We have between 2 and 4 working group members from this region on each of those bodies. For bank insolvency, we have 5 regulatory bodies from this region. When you note there's only about 10 nominated experts in each of this, it means that between 20 and 40% of these groups are made up by experts from this region, which again I think is quite a good result. It notes that there is certainly, we're certainly respecting and involving the Asia-Pacific point of view in the negotiation of and adoption of these instruments. Again, we're quite proud of. I note there on the right that in the negotiation and finalisation of the MAC protocol, we had at the diplomatic conference and the Committee of Governmental Expert meetings, we had 11 states from this region involved in those negotiations, which again is a very healthy number. And then finally, I tried to think some other metrics to assess whether people in the Asia-Pacific know what we're doing that doesn't involve government. And the easiest way to do that is look at our academic cooperation agreements. Of the 43 that exist, 8 of them are with institutes and universities in this region. Our scholarship, internship and research program. So about 20% of our applicants for next year came from this region. And I asked our website technician before I came over, and he confirmed that we have a large amount of traffic coming from this region to the UNIDWA website, thousands of visitors from across the Asia-Pacific to the UNIDWA website every year, which would indicate, again, there's at least a baseline level of interest across this region. However, we can clearly do better. So if that's where we're up to, partially the reason that it's very hard for UNIDWA to engage with the Asia-Pacific are these 3 limitations I've got on this slide here. So we're a very small secretariat. We have a team of less than 30 people, only about half of which are lawyers in Rome. We're based in Europe, of course, which is quite a long flight to get here, partially why we're all a little bit jet lagged today. And we have a very modest technical assistance budget. We don't have a large section of the Secretariat dedicated on a full-time basis to go out and help our member states. We all are responsible. Every single legal officer has their own ongoing project, as well as their implementation project. So we have no full-time, wholly dedicated resources to technical assistance, which means that we can only dedicate a certain amount of each officer's time to this area. So within these limitations, we've developed some strategies that we think are increasing and has potential to further increase engagement with this region. So the first that we found to be very successful is engagement with regional bodies and international financial institutions. Second is the conclusion of agreements, secondments and MOUs. Third is cooperation with partners, in particular our 2 sister organisations. And fourth is different degrees of private and civil sector cooperation. And I'll touch upon each of these very quickly now. So as James mentioned, one of the main methods through which we've developed such a close and valuable relationship with the Special Administrative Region of Hong Kong is through APEC, where of course Hong Kong is a member economy. So UNIDWA was invited to have guest status with APEC, the APEC Economic Committee, which James chairs. We were first invited in 2017 and we've been renewed twice. So our current mandate is extended till 2024 and we would hope to be extended again. This allows us to participate in the Economic Committee and, more importantly, the technical subgroups that sit under the Economic Committee. In particular, for us, the Strengthening Economic Legal Infrastructure, or CELI subgroup, which is all about the kind of instruments we've spoken about today, the promotion and the implementation and ratification of instruments that support economic development, that support cross-border trade, that support international cooperation and harmonisation of legal systems. This is a subgroup to the Economic Committee dedicated solely to these types of instruments, and it's been a wonderful way where we can send one officer to an event in Asia Pacific somewhere and speak to 23 member economies at once, which is much better for us than having to go to one country at a time, which is very, very difficult. So this has been one of the most successful ways that we've increased engagement with Asia in the past 8 years. I note all the various events that we've been at there. In terms of future opportunities, we would like to strengthen and continue our engagement with APEC, but also start to look to other regional fora that we haven't yet had a strong relationship with, such as ASEAN, when we're very pleased, as James noted, that the Secretary General will be speaking at the ASEAN conference later this week, which is a wonderful first step to further cooperation with that particular forum, and also looking at the Pacific region in particular. The Pacific Islands Forum is another possible option for UNIDWA to look at further regional engagement. We also have, we've also just begun this year increased engagement with the Asian Infrastructure and Investment Bank in Beijing and the Asian Development Bank in Manila, which we think are also valuable fora as they undertake the kind of financing and undertake the kind of technical assistance that we don't have the capacity to based on our instruments. So they're we cooperated historically a lot with the World Bank, but we want to also increase cooperation on a similar basis with regional banks in this part of the world. So number two, our second strategy has been the signing of agreements, MOUs, and secondments. So in particular, we note here that in the last 3 years, we've signed secondment MOUs with the Ministry of Commerce of the People's Republic of China, as well as a secondment MOU with the Department of Justice of the Special Administrative Region of Hong Kong that allows them to send lawyers to UNIDWA for between 6 months and 2 years to work with the Secretariat. And that has been a resounding success. We've already had several officers under both programs seconded. In fact, we've got staff right now who are probably listening from Rome into this presentation today who have been a wonderful asset to the Secretariat. And of course, when they finish their secondments, they go back to their home organisations and take all of that valuable knowledge about UNIDWA with them. So we think this has been a wonderful collaboration. We hope to expand upon it in the future. Similarly, earlier this year, we signed a cooperation MOU with the Special Administrative Region of Hong Kong, which will also further strengthen new opportunities for further collaboration and engagement in the promotion of international commercial law and private international law. Third is, of course, cooperation with partners. We have incredibly close relationship, especially with our two sister organisations here. These were already noted earlier by both our Secretary General and Secretary General of the Hague Conference. There's annual tripartite meetings. There's cross-participation in each other's working groups. There's publication of joint documents on our instruments. I personally was lucky enough to be in the Hague for the conclusion of the Judgments Convention and in New York for the adoption of the Model Law on Secured Transactions. This kind of close collaboration is extremely important to make sure that we all work harmoniously together. We've created the standing coordination bodies, such as the Joint Network for Coordinating and Supporting Secure Transactions Reform, which had a very successful meeting in Rome earlier this year. And by having this cooperation, it means that it's wonderful to all have us in the room together when these rare occasions happen outside our home region, but it means that we know when Untertrial goes somewhere or the Hague Conference goes somewhere, they'll also be flying the banner for all of us and making sure that all of our instruments are promoted alongside each other, which is a very important way to combine and pool our limited resources. And then the final new initiative that we've launched is the Secretary General early this year got approval from the Governing Council to sort of refresh our correspondence network, which is now a network of over 100 correspondents from around the world who are experts in either academia or the private sector or former government in different areas of the UNIDWA work program who are well connected to the legal sector in their countries. And they serve as almost informal ambassadors for UNIDWA's work and assist us in the promotion of our instruments in those countries. This has been around for a long time, but we've just invested a lot more time and energy into refurbing this network, and already it's paying dividends. We've already had a lot of assistance from these correspondents to increase promotion. And in fact, when the UNIDWA delegation goes to Manila next week, a lot of our program there has been facilitated by our Philippine correspondent. And I note there that of the 100 correspondents appointed, 23 of them are from the Asia-Pacific region from 10 different states. And then finally, the Scholarship, Internship and Research Program. We sign about 5 to 10 new MOUs every year. Several of those are always with institutes in the Asia-Pacific. China MOFCOM has been a significant supporter of our program, which has been of great value. It has also facilitated many excellent Chinese scholars coming to work with the Secretariat over the past 5 years. And also, this is not Asia-Pacific specific, but we have an improved and updated website, which makes it much easier to find out what we're doing. So in conclusion, we need to increase our member states in this region, and that will lead to more governing council members from this region. We need to increase ratification and implementation of our instruments. We need to involve more Asia-Pacific experts in the negotiation of our instruments. And we need to sign new MOUs and bring more scholars and interns in from this area. And we're going to do this by continuing to engage with regional fora such as APEC, seek out new fora like ASEAN, continue to utilise our increased correspondence network, and continue to cooperate with our wonderful sister organisations. Thank you very much.
Thank you, Will. Our next speaker is Professor Zhao. Professor Zhao is the representative of the Hague Conference on Private International Law of the Asia-Pacific Region Office in Hong Kong. Actually, tomorrow, the regional office of the Asia-Pacific will be celebrating its 10th anniversary tomorrow. And there will be another event during the Hong Kong Legal Week. So without further ado, I will pass the floor to Professor Zhao.
Thank you. Thank you, Chair. Ladies and gentlemen, it is a great honor for me to speak on this very important event regarding private international law in the Asia-Pacific region. Today, we have a lot of discussions regarding the UNIDROIT and UNIDROIT instruments, which plays a very important role in the commercial, in the digital economy field. I'm very pleased that we also have this special session to discuss about the private international law. So this can provide a very important occasion for us to share and exchange views in this field. As a representative of the Regional Office for Asia and the Pacific of the Hague Conference on Private International Law, I would like to talk about the significance and potential of the HCCH and its conventions for our region. I will also look to the future. What can we do? What can we further strengthen our engagement in this region? The rapid expansion of cross-border transactions, mobility of people, and family relationship within and outside the region would all benefit from the support of the international legal framework. The HCCH has taken this important role to facilitate international transactions and protect the interests of vulnerable parties involved. The HCCH conventions help to promote cooperation among courts and other authorities that are indispensable in the age of globalization and progressive regional integration. When compared with other regions around the world, the Asia-Pacific region is unique in many aspects. First, it is a region of many countries, and their geographical dispersion makes travel, including dispute resolution, more expensive. Second, as our chair just mentioned, the region is populated with different legal systems, including common law, civil law, hybrid legal system, etc. Third, multitude of different languages is spoken, making it more difficult for parties to access and understand the laws and procedures of countries they engage in business with. And fourth, the region is also made up of varying levels of economic growth, resulting in considerable differences in the sophistication of court proceedings and practices. The Regional Office for Asia and the Pacific, set up 10 years ago in 2012, plays a role to strengthen the ties between the HCCH and the states in the region. So this year, 2022, is exactly the 10th anniversary of our regional office. The regional office has an aim to promote the HCCH and its conventions by increasing awareness of the value of the memberships of the conference and the usefulness of the conventions to the region. It also brings benefit in terms of assisting states with the implementation of the conventions. As the HCCH's influence becomes more and more global, a growing number of Asia-Pacific countries join the HCCH and all its conventions, both benefiting from and contributing to the HCCH. Our first speaker has mentioned about the UNIDROIT's presence in the Asia-Pacific region. Probably I will briefly report about the presence in Asia-Pacific region. Since 2000, the number of HCCH member states has grown rapidly. Among these 44 new member states, 16 are from Asia. The increased membership base in the region will bring wide representation of a diverse range of legal traditions to the HCCH and help the HCCH to develop new instruments better adapted to meet the needs of our region. The Asia-Pacific region includes some of the world's most populous nations and some of its most commercially energetic. As people in the region grow in affluence, as they travel more, as borders become more fluid, so private international law grows in relevance to the needs of the region. Although the states in the Asia-Pacific region are geographically close, they represent a wide range of cultures and legal traditions. Private international law, with the intention to bridge different cultures and legal traditions, is thereby very useful in providing a framework for cooperation both for the states in the region and between those states and those located outside the region. It will also provide additional opportunity for enhancing certainty and predictability of cross-border private, commercial, and financial transactions and relationships, promoting judicial and administrative cooperation and reinforcing protection of children and other vulnerable persons in transborder cases. Benefits will accrue within the region and also between states in and outside the region. This can be very closely related to the portfolio of the HCCH, which was quite divided into 4 pillars. We look at jurisdiction issue. We look at applicable law issue. We also look at the recognition and enforcement of foreign judgment issue, but moreover, we are increasingly looking at the judicial, diplomatic cooperation and administrative cooperation. So we have thereby developed 3 pillars of conventions to realize our goals and objectives. In terms of cooperation between international organizations, the HCCH has maintained close relationship with regional organizations such as APEC and ASEAN. The states in our region has on various occasions emphasized the significant role of a sound legal framework in fostering economic and social development. A more uniform and harmonized legal framework will enable existing domestic infrastructure to facilitate the fair, efficient, and cost-effective resolution of disputes between businesses and people from different countries, enhancing cooperation towards post-pandemic recovery and create a stable, prosperous, and highly competitive economic region. Private international law is of significant practical importance in the implementation of the economic integration initiatives, in the promotion of inclusiveness and a harmonized cross-border legal framework. Looking into the future, we may need to seriously consider the following 5 issues. First, the concept of Asian private international law. It's quite interesting to look at the concept itself, Asian private international law. It is, for me, unrealistic to discuss about the unification of private international law in our region in view of the rich culture, rich historical background in our region. However, it will be useful to look into possible harmonization. As such, it is important to strengthen the research and education of private international law in the region. We need to have core teams of scholars and experts working together to explore the possible approach to realize the harmonization of private international law in our region. Second, When it comes to the Greater China area, it will be necessary to look into the issues related to inter-regional conflict of laws. I still remember 1998, at the time when I finished one dissertation, I wrote on the intertemporal conflict of laws. So now we are thinking about how to have the integration within the region of the inter-regional conflict of laws will be rather useful and very important. At the moment, mainland China and Hong Kong and Macau have reached bilateral agreements on judicial and administrative assistance in various issues. It will be necessary to explore conflict of law issues within the context of a sovereign state. Third, strengthen the role of the HCCH regional office in serving as a platform to facilitate the exchange of views and discussions on relevant private international law issues in the region through various means, including meetings, conferences, and informal discussions at different levels. Academics, officials, and administrators will be involved in this discussion process. Fourth, traditionally, we talk about private international law in the field of conflict of law issues. As I have just mentioned, the HCCH mainly deals with the three major issues: jurisdiction, choice of law, recognition and enforcement of foreign judgments. In mainland China, for a long time, we have quite a lot of discussions about narrow understanding of private international law and broad understanding of private international law. The two groups of scholars have always been in discussion or in struggling. With the ongoing process of harmonization and unification, we may need to consider some more international conventions touching on substantial issues which have been argued to be private international law in broader scope. But we will have to be very cautious in this approach. As our first speaker has just mentioned, the three organizations should work together to collaborate in various issues in our digital era. Fifth, international conventions have been considered most useful in the harmonization of the process in view of the difficulty and necessity. Where various efforts have been done in the conclusion of hard laws, we may also need to start thinking about the functioning of the soft law documents. The HCCH also has its first soft law documents in 2015 dealing with the international commercial contracts. To sum up, private international law provides those who live and activities across borders between different legal systems with a high degree of legal certainty and predictability. Apart from enhancing the ease of doing business, they also establish effective state-to-state judicial and administrative cooperation mechanisms that can overcome the challenges of cross-border procedures and promote the orderly and efficient settlement of disputes, good governance, and the rule of law. Private international law works for people and business alike, effectively helping them to overcome the daily practical challenges of private international law issues. It has a direct impact on people's lives and the way commercial operators conduct their cross-border business. The impact of private international law is rising, a changing global environment fanned by new technologies and digitalization requires strong frameworks which accommodate pragmatically differences between jurisdictions that otherwise would prove significant obstacles to trade, commerce, investment, and mobility. This is particularly relevant to the Asia-Pacific region, with rich cultural background, legal systems, and largest population. There's no doubt that private international law will bring about much practical benefits to our region in building bridges between legal systems and reducing obstacles to cross-border dispute resolution and reinforcing legal certainty and security across border, increasing the ease with which commercial policy and human capital can be best leveraged in a dynamic and fast-paced environment in our daily lives. This region is particularly attached or related to this latest development. So with this, I end my presentation. Thank you very much.
Thank you, Professor Zhao. Thanks for sharing the experience of the regional office and also from the perspective of the HCCH. Our last but not least, the speaker from UNCITRAL. Like the Hague Conference, UNCITRAL also has established an office in Asia, but this office is not in Hong Kong, it's in Korea. Having said that, we have very strong collaboration with UNCITRAL. We have seconded to this regional center of UNCITRAL in the past few years, every year. And also we have organized many activities together, especially in the past few years. I'm sure you will hear more from Jay. Jay, you have the floor.
Thank you. It's a pleasure to be as speaker and now the moderator for this session, at least. So I think today we're supposed to talk about how to strengthen engagement. I fully endorse what William said about the approaches that UNCITRAL is taking. UNCITRAL is taking the same approach, taking a regional approach, and I fully agree with Yoon in the sense that the aspects of PIL in this region may be a little bit different from how you look at it from Europe or from other regions. So we are coordinating in a sense. But what we have been able to overcome during the pandemic was the need for physical presence. And when we talk about strengthening engagement, you have to meet persons. You have to be in the room. You have to talk to the other persons. You have to understand each other. And the pandemic has taught us that we can overcome that by using technology. We have been able to have our working groups, our commissions in remote form. But one thing that we have not overcome is the time zone. It's because the Earth is round, and we cannot change that. And it is fair to say that it is unfair for certain parts of the region to be in their working time, whereas the other parts of the region is not in a working time. And that's why it is really something that we have to overcome. And one thing that both William and Yoon did not mention is that the Asia-Pacific region has a diverse of languages. It's not as, and that is something that we also cannot overcome, and I think that is something we need to think about as we think about strengthening engagement. So with that, I think I can keep my presentations quite short. You probably know what UNCITRAL is. In UNCITRAL, we have currently 70 membership. The membership has been increased from 60 member states to 70, but we have only elected 5 additional members. So currently, we have 15 members from Asia. We have very active participation, particularly with regard to remote, the means of remote participations that we have been able to provide. We have the same issues with the secretariat, that we have a very small secretariat. We're based in Europe, we're based in Vienna, and we have a very modest, almost little TA budget. So this is something that we have to overcome. But even in that case, we have had a number of new legislative projects that have been proposed from the region, one being the judicial sale of ships, another which is starting now, which is a new project on multimodal negotiable transport documents, which has been proposed by the People's Republic of China. Also, there is a project that has been proposed by Japan on dispute resolution in the digital economy. So the Asia-Pacific region is participating quite actively in the legislative aspects of UNCITRAL as well. But as I said, in order to be close by and to actually strengthen engagement, similar to the regional office for the Hague Conference, we established a regional center for Asia and the Pacific, RCAP, in Incheon, Republic of Korea in 2012. I was heavily involved in the establishment, so I'm quite happy to see that it is 10 years old now. It is supported by the South Korean government and Hong Kong, China, including secondees from the Hong Kong Ministry of Justice, the Korean Ministry of Justice, and the Hong Kong Department of Justice. So the regional center carries out UNCITRAL's mandate, particularly in promoting the use and adoption and uniform interpretation of UNCITRAL text and providing capacity building in this regard. In that context, UNCITRAL's regional center, RCAP, has organized a number of flagship activities, and over 70 technical assistance activities and coordination events over the last year. I just wanted to go quickly through the different aspects or the achievements that the regional center has been able to achieve with regard to the instruments on e-commerce, CISG, model law on international commercial arbitration, and on the Singapore Convention on Mediation, where you have seen a number of active participations from states in the region. It's either ratifying our conventions or adapting our model laws that are in this field. So what we hope to see is that actually these maps actually gets filled up more and more with states from the Asia-Pacific region as the time passes. So how do we actually collaborate, or how do we provide technical assistance? One aspect that, one new initiative that we have is we're trying to develop online courses. We have developed a very general introduction to UNCITRAL on the website, which is accessible on the UNCITRAL website, where you can obtain a basic understanding of what UNCITRAL does. But we're also developing modules on private-public partnerships, mediation, and arbitration. So we will actually be reaching out with the basic instructions or basic material about these texts in the coming years. One other aspect, we collaborate very closely with Hong Kong. This also relates to legislative aspects. As you know, UNCITRAL's Working Group 3 is working on the reform of investor-state dispute settlement, and we are cooperating quite closely with the Hong Kong Department of Justice, and we have hosted intersessional meetings as well as follow-up preparatory work, a forum to actually support the work of the working group. And hopefully, since the texts on investment mediations are to be presented to the Commission next year, we hope to hopefully have a drafting group in Hong Kong to fine-tune those provisions on investment mediation. Of course, the RCAP also has flagship events. These events are taking place in Korea this week. But with Hong Kong, we have held the Judicial Summit as well, and we have held one remotely in 2021, and we hope to hold one next year with Hong Kong. As William mentioned, we also take part in regional initiatives. As you can see, ASEAN and APEC activities are where we actually coordinate closely with UNIDROIT and the Hague Conference, and we have participated very actively in APEC and hope to make it back to the APEC sessions where James is chairing the Economic Committee. Another aspect, in order to reach out to the students or those who are going to be upcoming and going and knowing about international trade law, we have also what we call the Asia Pacific Days to reach out to the next generations of legal thinkers. We have done that with a number of institutions in Hong Kong, but this has actually broadened. It was one of the initiatives of the Regional Center for Asia and the Pacific, but from the Secretariat's perspective in the headquarters, we wanted to benchmark this, and therefore we have come up with UNCITRAL Africa Days, as well as the Latin American Days, whereby we're reaching out to universities in the Latin American region, as well as the African region as well. As mentioned, because this year marks the 10th anniversary of the RCAP, we are holding a RCAP at 10 event this Friday, and therefore that's why I have to actually fly out of Hong Kong today. I think, as you can see, we hope that the RCAP, by having a presence in the region, would actually have some role to play in regional trade, developing global standards and promoting them, as well as to achieve future of legal harmonization. So this is probably what RCAP will look forward to in the coming years, in the coming 10 years as well. There is also an exchange program with the Hong Kong government. As you can see, we have had secondees from Hong Kong since, I think, 2000, almost as with the establishment of the regional center. I see that one of our secondees are in the room. But they have actually been able to contribute very greatly to the work of the regional center. I mentioned very limited resources. the regional center has one head and two support staff, and therefore the legal experts that actually come to our regional centers to support our activities are a very valuable asset from our perspective. Lastly, this is some of the pictures that I got from our regional center. We have had a number of interns from the Hong Kong region. The interns from the Hong Kong are told to be very useful and contributive, and they are quite helpful in a number of the projects that we have carried out. So these are some of the pictures of the internships that we have, and we look forward to getting more applications from the Hong Kong students as well. So I think with that, I just wanted to highlight again that when we talk about strengthening engagement, I think we have to talk about the human nature. We have to meet, we have to see each other, we have to be in contact with each other more often in order to engage. I think that is the main nature, and then that is why we have established the Regional Center for Asia and the Pacific, and we hope to, I guess, further our collaborations and engagement with the region using the Regional Center, which is in the same time zone as the Asia Pacific region. With that, I'd like to conclude my presentation. Thank you.
Thank you, Jay. I think we still have a few minutes available for questions, and so maybe I will start with the questions with Jay. Actually, you were mentioning about the LCAP. Time zone is certainly one of the key aspects of the need for regional presence. Could you tell us or elaborate more how the establishment of a regional center in the region help to engage the Asia Pacific? Does it make a material difference, or it's just something nice to have but not really necessary?
Actually, I think the biggest positive impact of the regional center is that there is a channel of communications. Of course, we have email. The thing is, email doesn't really convey the ideas that you want to have. Just like the discussions that you and I had over lunchtime, it's a 10-minute talk that would actually resolve the issues and see how to move forward. But the email actually doesn't capture all of that, and it takes a very long thread of emails to actually understand what the other party has to say. And I think the establishment of the regional center established that channel of communications between the stakeholders in the region and UNCITRAL. It is possible that our head of the regional center, currently Atita Kuminder, is able to actually listen to the stakeholders, have their discussions in live, and then actually convey the ideas to the Secretariat in Vienna quite effectively, which actually helps the engagement and the coordinations that is necessary.
Thank you, Jay. So a similar question for Professor Zhao. Do you think that the establishment of the regional office in Hong Kong makes a material difference? You mentioned in your presentations that there is an increase of the membership in Asia Pacific. Do you see any increase after the establishment of the regional office in Hong Kong?
Thank you. First of all, I think I agree with Lee. I think basically, I think it's rather important. I think we can have a platform for communication and exchange of views, so sharing opinions. So I think we can reach some more understandings on the issue. It's rather important to see that the Hague Conference on Private International Law, since year 2000, I think around half of the member states were joined, I think actually after 2000. And within the 44 member states, 16 are from Asia Pacific region, so which appears to be a big proportion. If we look back, in early stage, when the HCCH started in 1893, it was considered to be Europe-centric. But now we can see it's more international, it's more global from all continents. So I believe the regional office will play a very important role to set up the platform for communication, to bring people, to bring the nations to have better understanding of the organization, its purpose, objective, and also its missions and its conventions.
Thank you. So the natural question for UNIDROIT is, UNIDROIT does not have a regional presence in this region for the moment. Will UNIDROIT, having heard the experience from Hague Conference and UNCITRAL, consider established presence in this region? What are the considerations? Yeah.
Thanks, James. That's a somewhat loaded question, isn't it? Well, it's obvious that the regional offices for both the Hague Conference and Australia have been huge successes. And there are obvious benefits in terms of language and having a presence, open communication, easy to travel to events, being able to involve member states in the region. These are obviously large benefits that both of your organisations have realised. The last couple of years has been a difficult time to consider the establishment of a regional or some sort of liaison office, given that it was impossible to travel to many parts of the world for the last 2.5 years. But I think obviously looking at the successes the other organisations have had, there's an issue that you needs to explore further.
Thank you. We have some questions from the floor, and I think we can answer one or two. I think the first question is for all the panelists. The question is very general and broad. Is there any plan of your organizations to utilize the network under the Belt and Road Initiative? Do you see any synergy between engaging the Asia Pacific and the Belt and Road Initiative? So, Will first.
Sure, absolutely. We see this as a natural international initiative under which many UniDuai instruments could be incredibly valuable for increasing not the establishment of the Belt and Road, trade along the Belt and Road, financing along the Belt and Road, and we hopefully will explore some of those instruments at the event later this week. But no, we certainly support it as we see it as an initiative where there is a lot to be gained from UniDuai instruments, and there's also a lot to be gained from the UniDuai perspective, because it will allow us to promote our instruments along this regional and international initiative in countries where in the past we may not have had a significant level of engagement and where we haven't had member states in the past. So yes, we certainly think that it's of mutual benefit.
Thank you. Professor Zhao?
Yeah, we are fortunate to have the regional office in Hong Kong, I think, which has an ideal geographical location linking the east and west. So we definitely will take into account the best geographical location to link the countries along the Belt and Road Initiative. I think that's rather important. We will organize various activities, and indeed, we have already had quite a lot of communications with the organizations within the region and extend beyond the region, so which can include the webinars, conferences, and also the negotiations regarding the membership and the membership to the conventions. Thank you.
Thank you. Jay?
If I can tilt the question, I would actually say that the Belt and Road Initiative has a lot to benefit from the work that has already been undertaken by UNIDROIT, UNCITRAL, and the Hague Conference, in the fact that there are existing legal standards that would actually apply to the Belt and Road Initiative. And rather than reinventing the wheel and trying to come up with the instruments for the Belt and Road Initiative, those who are responsible should actually be looking at us. And in that context, I think it is our role to raise the awareness of our existing text with regard to the Belt and Road Initiatives to ensure so that they actually are aware of what we have been able to achieve and what we're already conducting.
Thank you. Yes, I think certainly there will be some kind of synergy between the work you have been doing and also the Belt and Road Initiatives. It seems that we are running out of time. Our Secretary for Justice is already here, ready to give the closing. So maybe we finish our sessions, and to finish our session, please give a big round of applause to our panelists.
Thank you. A very round of applause to our panelists and also our moderator. Please stay seated, as we would like to capture this moment. So we will once again like to invite our official photographer right in front of the stage to take a photo for our moderator and our speakers on stage. So our distinguished speakers and moderator, please look at the official photographer right in front of you. Once again, ladies and gentlemen, a big round of applause to our moderator, Dr. Deng, our speakers, Mr. Bridie Watson, Professor Zhao, and Mr. Lee. Thank you so much for the insightful discussion indeed. Thank you, and please be seated. Thank you. Ladies and gentlemen, I guess today it's definitely a very fruitful and rewarding day for all of us, as we had 4 panel discussions for today. And to wrap up today's inaugural summit, we are honored to have with us today the Honorable Mr. Lam Ting Kwok Paul, SBS SCJP, Secretary for Justice of the Government of the Hong Kong Special Administrative Region of the People's Republic of China, to deliver the closing remarks. Ladies and gentlemen, let's put our hands to welcome Mr. Lam.
Professor Tirado, Dr. Bernasconi, Mr. Lee, friends from all international organizations, Council Generals, distinguished guests, ladies and gentlemen. It's a great honor for me to be here today to speak at the closing of the inaugural Asia-Pacific Private International Law Summit, jointly launched by UNITRA and the Department of Justice of the Hong Kong Special Administrative Region, which actually marks the opening of the Hong Kong Legal Week 2022. The Asia-Pacific International Law Summit was conceived pursuant to the mutual aspiration of UNITRA and DOJ to promote and further develop the understanding of private international law and international commercial law in the Asia-Pacific region. The summit is a particularly meaningful occasion because it denotes another milestone of our close partnership with UNITRA after the signing of our Memorandum of Understanding in May this year regarding our mutual collaboration on private international law and international commercial law. The summit is also particularly momentous as it has brought together in one arena the three sister organizations of private international law, UNITRA, UNCITRAL, and XCCH, all which the DOJ has been working very closely in the recent years with the support from the Central People's Government. We thank each organization for their trust in Hong Kong, and we look forward to even closer cooperation among us as we pursue our common goals to promote the development of private international law and rule of law in general. We have heard many insightful and excellent presentations today covering a very wide range of important private international law topics. The topics explored by our expert panelists today are timely and relevant to Hong Kong as a leading international financial and legal hub, as well as the greater Asia-Pacific region. Now, the first section this morning concerns facilitating access to credit in the Asia-Pacific region. Now, as a leading international financial hub with a robust legal system, Hong Kong continues to attract a multitude of financial institutions and organizations to conduct their businesses here. Asset-based financing and supply chain finance transactions are therefore an integral part of such businesses to access more credit and working capital. Now, in this respect, we have learned from the expert panel in session 1 on the important international instrument available in support of these secured transactions. International instruments such as the Cape Town Convention and its protocols are fine examples of efforts to harmonize international security registration requirements and legal remedies, giving more confidence to financiers to extend credit to businesses. It is also encouraging to see the continued efforts by UNITRA, XCCH, and UNCITRAL to further enhance harmonization in this area. For example, through the Model Law on Factoring project, another relevant instrument by all these organizations. Now, the second session this morning concerned providing legal clarity for emerging technologies, digital assets, and private law. Now, in recent years, in line with the global trend, the Hong Kong government has been actively seeking to strengthen and develop our digital economy. The local fintech and virtual asset industries have grown substantially, bringing with them numerous opportunities for financial innovations. Indeed, the Hong Kong government is also actively striving for new measures for virtual asset sector. The government has been working to put in place a comprehensive system for the regulation of these emerging markets to ensure their orderly and sustainable development. In this connection, once again, UNITRA, a digital asset and private law project which embodies best practices and international standards on the transfer and use of digital assets, is closely relevant. Today's discussions have given us much food for thought on how private international law principles may interact with the laws of our jurisdiction to regulate digital assets, especially in the light of their special characteristics. Now, the third section this afternoon is concerned about bridging the gap in the insolvency legal architecture. In addition to our efforts made on the technological development to promote business growth, we are also fully aware of the need to practice good risk management and even debt restructuring during the business life cycle. This is particularly important in the light of recent market volatilities and the complex issues that would commonly arise in international transactions. In Section 3, we have heard about the meaningful efforts being made to improve cross-border insolvency proceedings. An example of this is UNITRA's ongoing project of the bank insolvency, which is working trust and international soft law instrument to provide legal guidance for smoother cross-border coordination on bank liquidation proceedings. As well as one good domestic example is the record of meeting on mutual recognition of and assistance to bankruptcy insolvency proceedings between the courts of the mainland and Hong Kong SAR, signed between the Department of Justice and the Supreme People's Court of the People's Republic of China in May 2021, which provide for the mutual recognition of and assistance to insolvency proceedings between these two jurisdictions. The insights shared by the panelists on recent cases in this respect that have successfully utilized this arrangement are both enlightening and reassuring. The continued effective implementation of this unique arrangement would go a long way to facilitate and encourage the rescue of financially troubled businesses which have commercial presence in both Hong Kong and the mainland, which may also shed light for development of a cooperative mechanism for other jurisdictions and internationally. The last section, the fourth section this afternoon, is into the future, strengthening engagement in the Asia-Pacific region. The arrangement between the mainland and Hong Kong Special Region has also showed the importance of cross-border cooperation, which is indeed important for this region with very diverse legal system. Section 4, the last section, has highlighted the importance of cooperation and the need to strengthen engagement in the region, as well as the very close ties that Hong Kong has formed over the years with renowned international organizations in this regard. Now, as mentioned during the panel discussion, the Department of Justice has secured invaluable opportunities to second our local legal talents to the offices of UNITRA, XCCH, and UNCITRAL. Not only does this allow our lawyers to expand their knowledge of the operation of international organizations, it also allows us to inject some of our own perspective into the development of these international organizations and international law during such exchanges. Another aspect of our collaborated efforts in strengthening engagement within Asia-Pacific can also be witnessed through participation in the capacity-building activities as a member economy in the Asia-Pacific Economic Cooperation, APEC. With a view to promoting strong, balanced, inclusive, innovative, and sustainable growth in the region, we have been actively involved in the affairs of the Economic Committee, which is tasked to promote structural reform and strengthen APEC's economy's capability in both macro and microeconomic issues. UNITRA, UNCITRAL, and XCCH have all acquired the accredited guest status to participate in the meetings and activities of the EC. Lastly, we are very proud that Hong Kong is host to office for various international organizations with which we work in close association. The XCCH Regional Office of Asia and the Pacific was established back in 2012 while the Department of Justice Project Office for Collaboration with UNCITRAL was set up in 2020. It's also worthwhile to mention that most recently, the ALCO Hong Kong Regional Arbitration Center was opened in Hong Kong in May this year. They are all housed in the Hong Kong Legal Hub, in a very prime location on Hong Kong Island. These collaborations signify these organizations' unfailing faith in Hong Kong's rule of law, legal and dispute resolution services. It also cements Hong Kong's status as an international center for legal, deal-making and dispute resolution services in the Asia-Pacific region. We continue to welcome international organizations which are committed to the betterment of international law to join our legal hub and explore opportunities for further collaboration and for capacity building work in the region. It's our sincere hope that our close synergy may create more opportunities and better prospects for the Asia-Pacific region and beyond. Ladies and gentlemen, it's my pleasure to announce that the inaugural Asia-Pacific Private International Law Summit has come to a successful conclusion. The success of this summit is the culmination of the collective efforts and dedication of UNITRA and my colleagues at the Department of Justice, as well as the distinguished participants from different organizations. My heartfelt thanks goes to everyone who have contributed to the organization of this summit. Last but not the least, the summit and other events of the Hong Kong Legal Week 2022 would not have been possible without the steadfast and continuous strong support of the Central People's Government and other international organizations, including XCCH and UNCITRAL, for which we are deeply grateful. With the conclusion of this summit, the first day of the Hong Kong Legal Week 2022 also draws to an end. We welcome all of you to join in the rest of the exciting events that we have organized for you this week, covering a wide range of topics from transnational litigation, arbitration, and mediation to online dispute resolution, to the Law Society's Hong Kong's 5th Barron Road Conference, as well as the Rule of Law Congress on the last day, which is this Friday. These events would no doubt bring insight into building a more inclusive and sustainable future for the development of rule of law in this region. And I look forward to welcoming all to this event as well. Thank you very much.
Thank you. Thank you, Secretary for Justice, Mr. Paul Lam. Thank you. Please be seated. Thank you, SJ, for the wonderful summary of the takeaways at today's summit. Ladies and gentlemen, the inaugural Asia-Pacific Private International Law Summit has come to a close. On behalf of the Department of Justice of Hong Kong SAR of the People's Republic of China and also the International Institute for the Unification of Private Law, UNIDROIT, we would like to extend our greatest thanks to our excellent speakers and moderators for your insightful sharings and also discussions. A big round of applause to our moderator and speakers. Thank you so much. And definitely also to all participants located physically here or even watching the live broadcast online. Thank you for attending the summit and making it a great success. We would like to express our sincere thanks to UNIDROIT, the co-organizer of this summit, for your unfailing support to this event. We would also like to thank our supporting organizations, including the Asian Academy of International Law, the Hong Kong Bar Association, Law Asia, the Law Society of Hong Kong, and Invest Hong Kong. Before you leave, ladies and gentlemen, remember to take all your personal belongings with you. Please return your SI headset to the counter outside, and your feedback is important for us. So please do fill in the event evaluation form by scanning the QR code located at the exits of this conference hall. For our online participants, please also do remember to fill out the evaluation form before you log out. Once again, thank you so much for joining us today, and we hope to see you all again in the other events at the Hong Kong Legal Week 2022. Have a wonderful evening. Thank you.